Look, I support you, Dadvocate. I love what you're doing, but I gotta clarify a few things for you. And everybody else who doesn't listen. Shane, this is by no means intended to hate on you or disparage you in any way. But you, like many others, have failed to listen.
A very special topic on this Dadvocate live stream. Very interesting itinerary, because today we're talking child support. I know, everybody's favorite topic.
You see, you could have just left it alone, but now I have to audit you. Damn it.
An absolute delight. But specifically, I want to help debunk some of the myths around child support.
Oh no.
Because I think a lot of people have kind of a minimalist knowledge of child support. If you've
Oh boy.
never been hit with the beast, put through the meat grinder yourself, you likely just understand it to be, well, someone's gotta help pay for the kid.
You would think that was what it was for, but it is not. Blessing versus Freestone, 520, United States, 329, 1997. Respondents, 5 Arizona mothers' children are eligible for state child support service under Title 4D of the Social Security Act, filed 42 U.S.C. 1983 suit against petitioner director of the state child support agency, claiming, among other things, that they properly applied for child support services, that despite their good faith efforts to cooperate, the agency never took adequate steps to obtain child support payments for them, that these omissions were largely attributable to staff shortages and other structural defects in the state's program, and that these systemic failures violated their individual rights under Title 4D to have all mandated services delivered in substantial compliance with the title and its implementing regulations. They requested broad relief, including a declaratory judgment that the Arizona program's operation violates Title 4D provisions, creating rights in them that are unenforceable through a 1983 action and injunction requiring the director to achieve substantial compliance with Title 4D throughout all programmatic operations. The district court granted summary judgment for petitioner, but the Ninth Circuit reversed without distinguishing among the numerous provisions of the complex Title 4D program or of the many rights those provisions might have created. The latter court held that respondents had an enforceable individual right to have state achieve substantial compliance with 4D. It also disagreed with the district court's conclusion that Congress had foreclosed private Title 4D enforcement actions by authorizing the Secretary of Health and Human Services to audit and cut off funds to states whose programs do not substantially comply with Title 4D requirements. Blessing versus Freestone holds that Title 4D does not give individuals a federal right to force a state agency to substantially comply with Title 4D. Okay? Respondents have not established that Title 4D gives them individually enforceable federal rights. In previous cases, the court has been able to determine whether or not a statute created such rights. Okay? Right here. The statutory substantial compliance requirement does not give rise to individual rights. It was not intended to benefit individual children and custodial parents, but is simply a yardstick for the Secretary to measure the system-wide performance of a Title 4D program in the state, allowing her to increase the frequency of audits and reduce the state's federal grant upon a finding of substantial non-compliance. The Court of Appeals also erred in taking a blanket approach to determining whether Title 4D creates rights. It is readily apparent that many of the provisions of that multifaceted statutory scheme, including its substantial compliance standard and data processing, staffing, organizational requirements, do not fit any of the traditional criteria for identifying statutory rights. Okay? Although this court does not foreclose the possibility that some 4D provisions would give rise to individual rights, the Ninth Circuit did not separate out those particular rights, and it is not whether respondents sought any declaration of the rights being violated and an injunction enforcing substantial compliance. They don't have a right to it. They're not entitled to service. We Hunt versus Ledbetter, 875 F2D 1558 11th Circuit 1989. Presently before the court is a challenge to the program established under AFDC, which would be child support. Okay? The AFDC program, known as Title 4A of the Act, is a federal state welfare program for poor families deprived of support of one parent due to that parent's absence, death, or incapacity. The state administers program benefits in accordance with federal requirements, and the Department of Health and Human Services, which is responsible for program oversight, withholds or reduces federal matching funds if a state fails to comply. Okay? The AFDC program is a contractual arrangement by which the federal government and the state work together. The program is funded by both, with the federal government making payments to the states by a formula. The Secretary is empowered to evaluate. If the evaluation and audit show nonconformity, the Secretary must reduce or suspend payment. As a condition for receiving AFDC benefits, an applicant must assign to the state any support rights the family has and must cooperate with the state agency effort to establish paternity and collect support unless such cooperation is against the best interests of the child standard. Okay? Except for the first $50 of child support collected each month, which is paid to the family and does not affect AFDC eligibility. Okay? The state retains support collections to help offset welfare expenditures on the family's behalf. If a support collection exceeds the family's AFDC grant, the state will determine if such collection, when treated as if it were income, makes the family ineligible. Okay? The first issue on appeal is whether the complaint states a cause of action against the state defendant under 42 U.S.C. 1983. In Maine versus Thibodeau, the Supreme Court held that violation of a federal statute is cognizable under 1983. Since Thibodeau, however, the court has delineated two exceptions to this general rule. Section 1983 does not encompass claims based on statutory violations if Congress has foreclosed private enforcement in the enactment of the statute, or Congress has not created statutorily enforceable rights in the relevant statutory provision, Pennhurst State School and Hospital v. Halderman. The analysis here requires a determination if plaintiff has a right under a federal statute. If so, whether the federal statute precludes beneficiaries from seeking enforcement in a private cause of action. The Commissioner urged that Title 4D of the Social Security Act does not afford plaintiff an enforceable right as defined in Pennhurst. We agree and therefore find it necessarily only to discuss that issue. The state contends that Title 4D was enacted to recoup welfare benefit expenditures, to ease the burden on the state and federal fiscal, to check the rise of tide of families forced to resort to public assistance, and to reward states and maintain cost-effective and efficient child support recovery operations. By achieving net savings for federal, state, and local governments and welfare appropriations, Title 4D will benefit the general public. Although participation by the state in the Social Security Act itself is mandatory, participation under Title 4D is voluntary. It is enacted pursuant to the spending power of Congress. So then, Mr. Amin Osiris, it was never enacted into positive law, though. Right. Case law interpretation of Congress' power to legislate pursuant to spending powers recognized. Congress fixed the terms on which it so dispersed federal money to the state. It is much in the nature of a contract. In return for federal funds, the states agree to comply with federally imposed conditions. Pennhurst held that a funding statute that did not clearly condition the receipt of federal money on the implementation of certain procedures did not create any enforceable rights. They don't have a right. Title 4D is not for children, bro. Not for children, bro. Not for children, bro. Not for children, bro. Okay? Title 4D does not create any enforceable right. It was not enacted for the special benefit of AFDC families. A Title 4D program operates under a separate legislative and regulatory framework than that of the food stamp and social benefit programs under Medicaid. Title 4A provides funds from the public treasury to support children in need. Title 4D seeks to recover those funds, restore the treasury balance by enforcement of support obligations owed by the absent parents of these children. The driving force behind the program is to recover welfare payments and a parallel commitment to remove and keep families from the necessity of welfare dependence by establishing and enforcing support obligations. The legislative history indicates that in enacting Title 4D, Congress was primarily concerned with collecting child support in order to reduce welfare payments. It's not for children, bro. It's for your debt to society. The government thinks you owe it something because your baby mama went down and got on food stamps or Medicaid or baby daddy. Because it happens to everybody, not just men. Let's continue.
Usually the dad, right? That's probably your very basic knowledge of it. But if you've ever seen anybody go through it, or you yourself are going through it, you know it can be a lot more complicated. It varies from state to state. It varies from county to county.
42, United States Code 666, requirement of statutorily prescribed procedures to improve the effectiveness of child support enforcement, Section A. Types of procedures required in order to satisfy the state plan for child support. Each state must have in effect laws requiring the use of the following procedures consistent with this section and with the regulations of the Secretary to increase the effectiveness of the program which the state administers under this part. So, although the program may vary from state to state in different ways, it is essentially the same, and across the board, it violates your rights the same. I don't care if you're the custodial party or the non-custodial party or the child. It is violating your rights. And it's required to be in effect in each state and have these procedures in effect in that state. So it's all the same across the board. They just have differences in the way that they run their program. And that's it. The ground, the basis of the program is the same across the board. But each state goes about how they do it a little bit differently. So you're correct. And there's a caveat.
It varies depending on how much of the custody you have, how much custody you're allowed to have, and sometimes the custody doesn't even matter at all. You may be
That's correct.
surprised to learn throughout the next hour and a half or so that there are a lot of parents with primary custody who have like 90% of the time with the child and are still paying the other parent.
See, I told you, it's not intended to benefit women and children. But yes, a parent with primary physical custody can sometimes be ordered to pay child support due to income disparity. The formulas look closely at both parents' incomes. If the primary custodial earns a much higher salary than the non-custodial parent, the court may order them to pay the difference to ensure the child maintains a similar standard of living in both households. But also because they want their fucking money. If there are multiple children and the parents split them, meaning each parent has primary custody of at least one child, the courts calculate obligation for both sides if the higher earner pays the net difference. Most state guidelines factor in both parenting time overnights, and relative income, which is why they will not let you get any parenting time with your kids. Usually, as a dad, they will not let you get more parenting time, and this is why, because then they can maximize the child support. High income for the primary parent combined with low income for the other parent can flip the standard payment direction. But the thing of it here is that it's not for children, like I've already just established. It's to pay back the welfare expenditure that you get on behalf of your children. Now, if you were married and divorced, it's a little bit different, okay? You may have agreed to something, so then it may be legitimate actual child support, okay? But if you were not married, then it's not for children. It's for taxpayers. But I'll give you this one, you're correct.
Some bad actors online with absolutely no legislative or legal backgrounds at all, giving out bad information.
So you're not talking about me then, I take it.
Some people with legal backgrounds also giving out bad information.
Well, yeah, I mean, they're bar members. What did you expect? They're making money off of all of your children. Having a legal background has a little effect on what you know about child support. Not even most of the attorneys know what the child support program really is. It is administrative in nature. It doesn't have anything really to do with the judicial system other than it uses it for its own devices.
Brief disclaimer, I myself do not have a legal background, so none of what I'm about to share with you is legal advice. It's just, I'm a lady married to a dad who pays child support, who has been paying child support for the last almost 18 years. We're almost out of it.
Well, congratulations. He's almost through 18 years of extortion.
You know, we're never going to stop supporting the kid, right?
I have never supported that you not support your human offspring in your private capacity. I simply support that you made them in private, you take care of them in private without unlawful government intrusion to the private realm of your family life.
That's one of the biggest pieces of this channel. And also, as another disclaimer, as much as I fight for fathers, for the fathers to be recognized as equal parents, for fathers to stop being absolutely spanked by the family court systems.
They're getting absolutely spanked by the family court system because they keep showing up, giving them jurisdiction over them, and doing stupid shit and not listening. And that's their problem.
So to say, I'm not one of those people who thinks that the entire child support system should be abolished.
Sorry, Dadvocate, that actually doesn't matter because it's already abolished by law, and I'm going to get into that, and I'm going to show you why whatever you think in that particular aspect does not matter because the law has already abolished it. Let's get into that. Okay, 42 United States Code 1994, peonage abolished. The holding of any person to service or labor under the system known as peonage is abolished and forever prohibited in any territory or state of the United States, and all acts such as Title 4D of the Social Security Act, laws such as child support laws, resolutions, orders such as court orders to pay child support obligations, regulations, or usages of any territory or state which have heretofore established, such as establishing paternity, maintaining, such as child maintenance, or enforced, such as child support enforcement, or by virtue of which any attempt shall hereafter be made to establish, maintain, or enforce, directly or indirectly, the voluntary, child support is voluntary, or involuntary service, going back to work to pay your child support or go to jail is not voluntary, or labor of any persons as peons in liquidation of any debt or obligation or otherwise are declared null and void. Okay? Null and void means without any legal force or effect. Peonage is a system of forced labor or debt servitude where an employer or creditor forces a worker to pay off a financial debt through unpaid or low-wage labor. Workers become trapped because their earnings do not cover living expenses or inflated costs charged by the employer. Laborers cannot legally leave their jobs until the perceived debt is fully paid. It was common in the post-war civil American South. Convict leasing. The United States outlawed peonage through the 13th Amendment and anti-peonage laws passed in 1867. Now, how does that apply to the child support people? Is child support a debt? Yes, court-ordered past due child support arrears are legally classified as domestic support obligation and treated as a debt. Okay, that's all I needed it to answer. I didn't need to tell me that it's a duty, because you can't have a duty to labor for someone else placed over you. That is slavery. Support obligation as obligation to state amount discharge in bankruptcy. In other words, child support is an obligation. At 42 U.S.C. 666, requirement of statutorily prescribed procedures to improve the effectiveness of child support enforcement. A, in order to satisfy the state plan, each state must have in effect laws requiring the use of the following procedures, which is across the board, every state, every county. Expedited administrative and judicial procedures, which violates the separation of powers doctrine in the Fifth Amendment because and 14th Amendment, because expedited procedures allow for the violation of due process of the law. Okay, including the procedures specified in subsection C for establishing paternity, such as establishing peonage, and for establishing, modifying, and enforcing peonage, because this is a support obligation. The Secretary may waive the provisions of this paragraph with respect to one or more political subdivisions, which is a county, within the state on the basis of effectiveness and timeliness of the support order and enforcement of paternity establishment within the political subdivision, which is a county. It's the same in every county. So if they're doing it different in every county, they're doing it wrong. 42 United States Code 666A4 liens. A, liens arise by operation of law, which means it's going to happen whether you do anything about it or know about it or not. Against real and personal property, 4th Amendment, for amounts of overdue support owed by a non-custodial parent. We're going to get into that at some point, I can tell. Who resides or owns property in the state. You got a right to own property, don't you? So who the fuck can come violate your rights, okay? The state accords full faith and credit to liens described in paragraph A. So then they should give you full faith and credit when you apply Holmberg versus Holmberg, Minnesota Supreme Court case that said administrative child support is unconstitutional. Okay? Except that such rules may not require judicial notice or hearing prior to the enforcement of such a lien, which is a violation of due process of the law. 42 United States Code 666A15, procedures to ensure that persons owing overdue support work or have a plan for payment of such support, procedures under which the state has the authority in any case in which an individual owes overdue support with respect to a child receiving assistance under a state program funded under Part A food stamps, to issue an order or to request that a court or administrative process which violates the separation of powers doctrine established pursuant to state law which cannot violate the federal constitution, issue an order issuing peonage is abolished, okay? That requires the individual to pay such support in accordance with a plan approved by the court or at the option of the state, a plan approved by the state agency. The 4D agency is not a state agency according to federal definitions, so that's impossible. Administering the state program under this part, or if the individual is subject to such a plan, is not incapacitated, participate in such work activities as defined in section 607D of this title, as the court or at the option of the state agency administering the state program under this part deems appropriate, which is involuntary servitude and forced labor. Work activities, unsubsidized employment, subsidized private sector employment, public sector employment, work experience, on-the-job training, job search and job readiness assistance, community service program, vocational educational training, job skills training, education directly related to employment in the case of a recipient who has not received their diploma, satisfactory attendance at a secondary school or course of study, the provision of child care services to an individual who is participating in a community service program. So they're gonna make you go back to work, okay? Which is forced labor. So, them forcing you to labor is a system of peonage. Bailey versus Alabama, 219 U.S. 219. Prima facie evidence is sufficient to outweigh the presumption of innocence, and if not met, opposing evidence support a verdict. But the validity of a statute that authorizes the jury to convict on prima facie evidence must be judged by the fact that the jury may convict even if it's not made by the duty to do so. But what we're looking for, although a state statute in terms to be to punish fraud, if it's whether it is or isn't, if its natural and inevitable purpose is to punish for crime, for failing to perform contracts of labor. Title 4D is a contract. Blessing versus Freestone, We Hunt versus Ledbetter. They force you to labor. 42 United States Code 666A15, thus compelling such performance, it violates the 13th Amendment and is unconstitutional. A constitutional prohibition cannot be transgressed indirectly by creating a statutory presumption any more than by direct enactment, and a state cannot compel involuntary servitude in carrying out contracts of personal service by creating a presumption that the person committing the breach is guilty of intent to defraud merely because he fails to perform the contract, or thereby forcing him to do the contract. While its immediate concern was African slavery, the 13th Amendment was a charter of universal civil freedom for all persons of whatever race, color, or state under the flag. The words involuntary servitude have a larger meaning than slavery, and the 13th Amendment prohibited all control by coercion of the personal service of one man or one person for the benefit of another. While the 13th Amendment is self-executing, Congress has power to secure its compliance by enforcement by appropriate legislation of the Anti-Peonage Acts. A peon is one who is compelled to work for his creditor until his debt is paid. When a custodial parent applies for government benefits like TANF, federal law requires them to assign their child support rights over to the state. At that exact moment, the child support agency ceases to act as a mere third-party administrator and formally becomes the primary legal creditor. The money is no longer treated as a private family matter. It becomes a debt owed directly to the government to recoup public welfare expenditures. The case I cited, We Hunt versus Ledbetter, is the definitive federal precedent proving this exact reality. Therefore, it is peonage. The federal anti-peonage acts are necessarily violated by any state legislation that seeks to compel service or labor by making it a crime to fail to refuse to perform it, such as child support obligations. Whether it is a civil duty to your child or not is irrelevant, and that's actually not what it is because of We Hunt versus Ledbetter. So courts consistently ruling that it is a civil duty and obligation are incorrect. They are basing their presumption upon a mistake in the interpretation of legislation. United States versus Kosminski, 487, United States 931, 1988. After two mentally retarded men were found laboring on respondent's farm in poor health and conditions, respondents were charged with violating 18 United States Code 241 by conspiring to prevent the men from exercising the 13th Amendment right to be free from involuntary servitude, violating 18 United States Code 1584, which does guarantee a private right of action, due to peonage being an element of racketeering, which means there is a civil recourse of action if two or more persons are involved within 10 years committing this peonage. And in the child support program, that happens on a daily basis with more than hundreds and hundreds of thousands of people. So, it is abolished. Means of compulsion, sufficient in kind and degree to subject a person to have the same general station in life as the alleged victim to believe they had no reasonable means to escape and no choice to accept but to accept and remain in the service of the employer. You're gonna go to jail if you don't go back to work to pay that child support obligation.
There are things that I do believe, like that if custody is 50-50, there's really no need for child support.
Good, that's correct. Equal protection clause.
I think that 50-50 should pretty much be the standard. It's generally appropriate outside of cases of very negligent findings, I will say.
What you are referring to is the strict scrutiny standard.
To avoid using any of the trigger words that YouTube auto smites your monetization for. But you're going to hear some fathers' rights advocates and family reform advocates say things like, get rid of child support altogether. And to them, I'm like, bro.
Family court blackmail, extortion, bribery, color of law, deprivation of rights, abuse of authority, perjury, conspiracy, duress, threatened abuse of legal process, mail fraud, kidnapping, embezzlement, and false imprisonment, peonage, and slavery.
Court judges are typically geriatric and looking like they were Jurassic. I'm snacking on them like a Velasic, a tisket, a tasket. Put the court order in a basket, and you better be making it brief for the C4 action will be classic. Not to do anything drastic, but I'm past it with the fastest on these fascists and classless masses of disastrous and blasphemous sadomasochists bigger than an actress made of plastic, having them standing there rambling in a Mandarin and Pandaren and gerrymandered arena meandering, and they commanding them to be belt sanding again before I get to gallivanting. Before I get gargantuan, I'm going on a tangent while they're having a tantrum. I smack him like a spatula, looking like I was Dracula, terrifying like a tarantula. I will last them with a lance, sitting in a stance in advance. There was a dirty human trafficking named Richard Branson, having the assets like the CIA to Charles Manson. No Prince of Donald Ray, Cupid and Blitzen. I'm a one-man army on a mission to put my enemies out of commission. I put them up in a critical condition and put the pros in position. Go with kamikaze on the Kawasaki, get to them having the lobotomy for making the monopoly of the economy and every night of me, you know. it when I get after the venom. The step that they mistake of sentiment for my rhythm is having no synonym, not even nailing them. The sadistic and criminalistic dipsticks, making it seem as if they were individualistic. But I am a mystic and I'm humming, don't belligerent. My omniscience imminent when I'm strengthening, I'm making switching, then having them after me like kids when I'm watching them go ballistic. They get offended when you're relentless because they want you to be senseless. But I will be having them regretted when I'm back and I'm black. I've been rigid not to be altruistic, but their fraud is both intrinsic and extrinsic. Not to be a cynic, but when I spit it I get sicker than a clinic. But I will be finishing young, but expect I'll be shedding it.
Family court, corruption, I will leave him in complete destruction, like human combustion or in compassion. There is no discussion, I will leave him like a carcass in a sarcophagus. When I leak it, archie and magic with my esophagus on top of it with a couple lozenges to release my consciousness. I sent him to hell with Islay Maxwell with what looks like a magic spell. But you know I gotta hit him with the ether, got them coming back like a golden retriever. If I was a missile, I would make them sizzle like a heat seeker. When I chop it up on the corrupt, when I'll be swinging like a meat cleaver. Immoral violations, involuntary servitude for Title 4D of the Social Security Act. Manipulation.
Hey you, yeah you. There's a arrow button underneath this video if you want to go ahead and share it with 2 people, and you want to take that share button and send it into outer space with Elon Musk's space Tesla. I would highly appreciate it. And please feel free to comment. No offense by anything I put out, but I'm just here making sure you know what's going on when it comes to this stuff. I'll be putting out more. This is only part 1. I have a lot of audits to go, and so I'm sure this will be a lot more content. I've got the law guide coming as well. I've got the app going on the back burner, so I'm going to be having my machine friends take a look at that, and then I'll be starting my series on how to get this climate change stuff under control. I have a device to unveil. So, that being said, I would appreciate your support of my channel. Please share this with at least 2 people. Trying to get the word out there and everything like that. And so, I'm sorry, Dadvocate, but it needs to be done away with and replaced with something that's actually going to benefit children. Because right now, it's just about kidnapping. That's what they're doing. But anyway, so Dadvocate here. Please listen. Why are people not listening? It's real simple, folks. Anyway, with that, I'll see you next time. Have a good one.
I'm Mr. Obsidian. Prepare yourself for the Man of Black.